conduct leading up to this and the circumstances which this offense occurred were outrageous and demonstrated a profound disregard for human life and the safety of others. At the time of the shooting, Mr. Sheffey was killed in cold blood by prior calculation and design, as the jury found. He was not the only person whose life was placed in jeopardy that day. As just outlined by the state, Brian Adams and Jeffrey Lee were in that vehicle that were subject to that gunfire. Two other completely innocent individuals, Mr. Reynoso and Mr. Ramirez, were simply going about their day when they were struck by that gunfire. Those individuals were not participants in whatever dispute or circumstances that gave rise to the incident. They were innocent people who happened to be in the wrong place at the wrong time. Their lives were endangered by the reckless and violent conduct of those involved, including other members of the public. Mr. Atterberry, you made that choice to involve yourself in this conduct. You could have simply ignored it. You could have walked away. You could have chosen not to participate. Instead, you chose to become involved, and the choice had consequences that can never be undone. The court recognizes there are consequences beyond the defendant himself. Of course, your family and friends did not commit the offense. They were not responsible for what happened, yet they too will suffer as a result of the sentence the court is required to impose today. The court does not take that lightly, and the court recognizes their pain as well. But the court must also recognize the pain of the victims and their families, the life that was taken, the lives that were placed in danger, and the consequences of those that will remain with those individuals and their loved one. As the sentence of the court, I have considered the record, the oral statements made. Of course, I reviewed the victim impact statements. I reviewed the sentencing memorandum issued by the defense. Considered my conference in chambers with counsel, the statements of the defendant, statements of the defendant's counsel, as well as the prosecutor. Consider the overall purposes of felony sentencing pursuant to Revised Code 29-2911. Is to protect the public from future crime by this offender and others, to punish the offender, and promote the effective rehabilitation of this offender, using the minimum sanctions the court determines to accomplish those purposes without imposing an unnecessary burden on state or local government resources. I consider the need for capacitation, deterrence, rehabilitation, restitution, along with that public burden on governmental resources. I consider the recommendation made by the parties. I reasonably calculated the sentence to achieve the overriding purposes of felony sentencing, being commensurate with, not demeaning to, the seriousness of this offender's conduct, its impact on the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. And using my discretion to determine the most effective way to comply with the purposes and principles of felony sentencing, I've considered all the relevant seriousness factors in B and C of Revised Code 29-2912, and recidivism factors in D and E of Revised Code 29-2912. Clearly, with respect to the seriousness factors being more serious than conduct normally constituting the offense, the victims of this offense suffered serious physical, psychological, or economic harm as a result of the offense. I don't find any of the less seriousness factors apply. With respect to recidivism being factors indicating offenders more likely to commit future crimes, for a lot of the reasons set forth by Ms. Blake just now very eloquently, I don't believe that the offender does show genuine remorse. There's just the one prior conviction as a juvenile. Factors indicating the offender is less likely to commit future crimes are, again, no prior criminal convictions other than the one juvenile conviction. So prison is obviously mandatory. The court's going to find that prison is consistent with the purposes and principles of felony sentencing. Defendant is not amenable to available community control sanctions. First, the defendant shall serve a mandatory prison term of 3 years in prison for the firearm specification in count 1, an additional mandatory prison term of 3 years on the firearm specification on count 12. Those two firearm specifications shall be served consecutive to each other, but also served prior to and consecutive to all the other prison terms that must be imposed today. As to count 1, the court determines that the defendant shall be imprisoned for a term of life in prison without parole, again with that firearm specification. Defendant is also ordered to serve an indefinite prison term of a minimum of 8 years, of 8 years on counts 5, 6, 7, and 8. 5 and 6 will be concurrent to each other, 7 and 8 will be consecutive. Count 12, that is where the public was the victim. Court imposes 36 months. Again, court finds that that firearm specification will apply because, in fact, the public was the victim for the discharge of firearms on a prohibited premises. Respect to counts 13, 15, and 17, all those counts will be 11 years. count 13 being the most serious, so that will be 11 to 16 and a half years to comply with the raving toke statute. Counts 19 and 20, those will be 36 months each. So I would like to run that would be counts 1, 7, 8, 12, 13, 15, 17, 19, and 20 are consecutive. So if there's a total of life in prison without parole, plus 64 to 69 and a half years. There is credit for 398 days. If I didn't say so, 5 and 6 are concurrent. The prison term will be served at the Lorraine Correctional Institution. More than the minimum is required in this case. Prison is needed to protect the public from future crime. The minimum sentence in this case would have demeaned the seriousness of the offender's conduct. Consecutive service is necessary to protect the public from future crime or to punish the offender is not disproportionate to the seriousness of the offender's conduct and the danger the offender poses to the public, as well as at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct. The harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflects the seriousness of the offender's conduct. With respect to the maximum sentence, with respect to count 1, the offender committed the worst form of the offense. The offender does pose the greatest likelihood of recidivism. Again, I disagree with the defense's characterization of the fact that the streets of Painesville became essentially a place where just gunfire was unleashed and it didn't matter who was hit by it. With respect to financial sanctions and considering Mr. Martin's argument with respect to that, I do find, considering the defendant's present and future ability to pay any financial sanctions, that if any fine that the court would have imposed would have exceeded the amount which the offender is or likely able to pay, therefore there is no fine. The defendant is ordered to pay the cost of prosecution. In the event that there is any post-release control, I'm still required to advise on that. Post-release control would be part of that sentence on the kidnapping and other charges, where you may be on post-release control for a minimum of 2 up to 5 years, as determined by the adult parole authority. If you are placed on post-release control and violate any of the conditions of your post-release control, the adult parole authority is allowed to impose more restrictive post-release control sanctions and return you to prison for up to 9 months for each violation, up to a maximum of half of your stated prison term. The violation of post-release control is a new felony. You may be prosecuted for the new felony. In the court which you are being prosecuted for that new felony may impose an additional consecutive prison sentence for a post-release control violation. Maximum prison term for a post-release control violation would be the greater of 12 months or the period of post-release control for the earlier felony, minus any time you've spent under post-release control for that earlier felony. The court's also required to make raving toke advisements. Advisement number 1, there's a rebuttable presumption you shall be released from the service of your sentence at the expiration of the minimum term or presumptive earned early release date, whichever is earlier. Number 2, the Department of Rehabilitation and Corrections may rebut that presumption if at a hearing held by the Department of Rehabilitation and Corrections they make specified determinations regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification. Number 3, that if, as described at the hearing, Department of Rehabilitation and Corrections makes specified determinations and rebuts the presumption, they may maintain your incarceration after the expiration of that minimum term or after the presumptive earned early release date for the length of time the Department of Rehabilitation and Corrections determines to be reasonable. Number 4, the department may make specified determinations and maintain your incarceration more than one time. Number 5, if you've not been released prior to the expiration of your maximum prison term imposed as part of the sentence, the offender must be released upon expiration of that term. Now I'm going to read you your appellate rights. Number 1, you do have the right to an appeal in this matter within 30 days after filing of the court's sentencing entry. Number 2, if you're unable to pay for the cost of a transcript, record, and all relevant documents required for the appeal, that would be provided at no cost to you. Number 3, if you're unable to pay for an appeal, you're entitled to have a notice of appeal filed without the payment of a filing fee. Bond at this point, if any, would be released. Is there anything else on behalf of the defendant at this time?
Yes, Your Honor, just ask that you order the transcripts at the state's expense as Mr. Atterberry remains indigent and consider appointing appellate counsel. Thank you, Judge.
All right, thank you. The court will appoint appellate counsel at the appropriate time.
Thank you.
Anything on behalf of the state?
Can I say it, Your Honor? Honor, just for the record, no sentence will be imposed on the remaining firearm specifications, is that?
Oh, I didn't say that. Yes, that's correct. It's
Okay.
just the two most serious. Counts 1 and 12.
Nothing else from the state, thank you.
All right, thank you. That we're adjourned. Thank you.